for the teams and the board and guests. Please touch nothing on the tables. I notice that the staff has poured water into the water glasses. Please don't touch it. We're not serving water here. Please be seated. Please be seated. Any white table is fine.
This is a mic test.
Good morning, and welcome to the 23rd edition of the Willem C. Vis East International Commercial Arbitration Moot. This morning, the final rounds in the arbitration between Orcus Worldwide Limited and Darwin National Foods PLC will commence in a moment. The tribunal, which will join me on stage in a moment, is the chair. Who's the chair? Okay. We have the Honorable Justice, Madam Justice Mimi Chan, who will chair the tribunal. And with her, we have Dr. Ingeborg Schwenzer, whom everyone knows, the Queen of the CISG. Oh. No harm done? I did the same thing a moment ago. And Vivek Hilanandan of the SIAC, please join us. And before I introduce the finalists, would I just remind you, for those who just come in, please touch nothing on the tables. At the end of the session, the judges will retire to deliberate, and we will all leave this room. And I'd like you to leave the table exactly as you found it. Don't leave anything with you. Anything that you leave will be removed. So please make sure that you leave and don't take anything that isn't yours, and don't leave anything that is yours at the end of the round. So we have as our finalists this morning, representing the claimant, Orcus Worldwide, is the team from Humboldt-Universität zu Berlin, represented by counsel Olivia Stolzenwald and Paul Marquardt. Darwin National Foods, the respondent, is represented by the team from Hidayatullah National Law University of Raipur. Represented by counsel Gaurav Agrawal and Soumya Jain. So with that, I pass it to the tribunal, and best of luck to each of you.
Thank you. Ladies and gentlemen, this is the hearing of the case of Orcus Worldwide Limited and Darwin Natural Food PLC. The tribunal always encourages the parties to be able to negotiate and agree on matters as much as possible to focus on the issues in dispute and always attempt to narrow the issues of dispute. So we hope and expect that you have been able to agree by now as to the time and the manner of proceeding this morning. Am I correct?
Yes, thank you, Madam Presiding Arbitrator. The parties have conferred and they have agreed on the following procedure. Respondent shall go first on the procedural dispute, then claimant shall answer, and claimant shall start on the merits, followed by respondent on the merits. Each speaker shall have 14 minutes, leaving 1 minute for rebuttal and surrebuttal, respectively.
Before we commence, though, I understand that we may have some questions, and I will leave it to my members of the tribunal to raise the question that we would like the teams to address us on.
Yes, ladies and gentlemen, you briefly discussed with our presiding arbitrator the question of which law to apply to the interpretation of the dispute resolution clause. But this tribunal has had second thoughts about it, and so we wanted to invite you to enlighten us which law we should apply to the dispute resolution clause and why. And maybe we start with claimant in this case.
Thank you, Madam Arbitrator. The parties have agreed in the procedural order number 1 to apply the SIAC not only to the sales contract, but also to the arbitration agreement.
Yes, but on which basis? Were you allowed to agree on the application of a certain law to the dispute resolution clause?
Based on party autonomy and the lex arbitri, the Danubian arbitration law in the present dispute, which is a verbatim adoption of the uncitral model law.
Okay. What is the position of respondent?
As respondent, we says that the arbitral clause is indeed governed by CIG. However, this clause shall be interpreted to apply the latest version of the institutional rules.
Actually, if this tribunal were to apply the law of the seat, would the outcome be different, or could we just say, okay, let's apply the law of the seat, which is Danubian law?
Under the UNIDRA principles, which are the Danubian law, the law of the seat, under Article 4, the interpretation standard would still be the same, an objective test and a subjective test based on the party's intent and the understanding of a reasonable person, considering the circumstances surrounding.
Is that your position also,
Members,
counsel for respondent?
the respondent is very fine with the application of the uncitral model law, that is the lex arbitri of Danubia in the present case.
Yes, but if we were to apply the substantive law of the seat, the substantive law of Danubia, would the outcome be different?
As for the respondents, we do not contend that there would be any difference in the outcome if such law is applied.
But isn't Danubia a common law country?
That is true. Danubia is a common law country. However, we can consider the UNIDRA principles as well as common law. And also when we turn to common law, the intent of parties is always relevant, and courts assess and tribunals assess worldwide also what a reasonable person would understand.
Well, questions of admissibility of documents, admissibility of evidence may have a difference.
That is true, Madam Arbitrator. However, in this case, the document...
There is a dispute as to the intention of the parties and what documents to be used to construe the meaning of the relevant contract clauses.
There is a dispute between the parties to which rules to apply for the second issue, the disclosure of the third-party funding agreement in the procedural dispute. And here the SIAC rules are the relevant guidelines when ordering disclosure or not. And as to the first submission, the party autonomy, if the SIAC rules 2016 or 2025 apply, the party autonomy is also the cornerstone of arbitration in common law jurisdictions.
I would like to ask counsel for respondents, is there a difference between common law principles on interpretation of the contract and the CISG?
Members, the CIG forms a broad framework for the interpretations of the contracts of sales and good. However, the common law is an adoption of the law that has been going on that might find variety in the different countries. However, CIG provides for a uniform application of the laws in the interpretation of the contract with sales of goods.
All right, then shall we move on to your submissions?
Members of the tribunal, counsel for claimant, and all my colleagues present here. Good morning. I'm Gaurav, and today I'm representing the respondent, Darwin Natural Food PLC, on the procedural issues. And my co-counsel, Soumya Jain, will be dealing with substantive issues. In the world which has accepted dynamism as a common practice, the claimant's case depends on freezing time and freezing intention by relying upon an older version of rules to hide its materially relevant documents. Against this backdrop, I will be making two submissions over the course of next 14 minutes. First, the SIAC Rules 2025 should govern this present arbitration. And second, the tribunal should order the disclosure of claimants' third-party funding agreements. Starting with the first issue, my arguments herein will be two-pronged. First, the term current in the arbitral clause should be interpreted to apply the latest version of institutional rules.
Counsel, does it make a difference which set of rules we apply? The older ones or the new ones?
Can you please repeat your question, Madam Arbitrator?
Does it make a difference whether we apply the old rules or the new ones?
Allow me to answer that in two parts, Madam Arbitrator. Indeed, it does make a difference. Firstly, there will be violation of substantive rights of the parties as the newer rules provides this tribunal with better case management powers that is highly relevant to the present case because of two instances. Firstly, Rule 47 of SIAC Rules 2025 provides this tribunal with the power of early dismissal of claims. In the present case, members, claimant has reserved a third claim that they have clarified they will be claiming funding cost in the furtherance of this arbitration. This tribunal will have the power to deal with that claim in the newer rules. And secondly,
But we could do that under the old rules too, couldn't we?
Indeed, Madam Arbitrator, the old rule does not specify a specific provision for that power. However, the more important change that will be more relevant in the present case is the newer rules define the ambit of the disclosure power of the tribunal. The older rule indeed provided general powers. However, the newer rules specified such ambit by introducing a disclosure power for third-party funding agreements. That makes it the tribunal for the tribunal to manage the case more efficiently, and as third-party funding is a core dispute in this present arbitration, it becomes highly relevant to determine which of the rules shall be applied.
Can I ask you, assuming we are with you, assuming the tribunal is with you that the 25 rules ought to apply, do you say that it is up to the tribunal and the tribunal has the power to allow the claimant to amend its notice of arbitration and provide for the new rules in the notice of arbitration? Or do you say that the only power or the only consequence of your argument being upheld is that the arbitration must be terminated?
Indeed, Mr. Arbitrator, I will agree with Mr. Arbitrator on the first part of his question, as the parties and the tribunal in the Procedural Order 1 have agreed that the determination of SIAC Rules 2016 in the early stages was of preliminary nature. Therefore, after determination of rules by the tribunal, it will not affect the continuance of the proceedings and the parties will not need to initiate any new proceedings. Therefore, as put forward by Mr. Arbitrator, the tribunal can order the claimant to merely amend their notice of arbitration and continue the proceeding under SIAC Rules 2025. Coming on to establishing why the current word shall be meaning to the application of SIAC Rules 2025. Members, for reference, firstly I would like to invite this tribunal to page 13 of the case file. Claimant Exhibit C3, the new sales agreement. Is the tribunal with me? Shall I proceed, members?
Which provision are you relying on?
Clause 15 in page 13 of the case file. In the fourth line from the top, if the tribunal could read with me, in accordance with the current arbitration rules of the Singapore International Arbitration Center. Members, respondents' stance regarding the interpretation of the word current is that of what every prudent and reasonable party would take it to be. That is towards the application of the latest version of institutional rules applicable, because the parties did not incorporate any specific version of the rules in the arbitral clause, and it is the established common practice in international arbitration to apply the latest version of institutional rules. To substantiate the same, I would like to highlight the case of AQZ versus ARA, wherein the Singapore High Court in 2015 held that an arbitral clause should be interpreted to apply the newer version of institutional rules, and if parties wish to deviate, they must expressly incorporate the same. Members, even if we were to use Article 8 of CIG to interpret this arbitral clause, as respondent, we rely on paragraph 2 of Article 8, which provides for the interpretation of a clause from a standpoint of a reasonable third party with the factual background known to the parties at the time of contracting. Members, the factual background known to respondent at the time of contracting was limited to its own interpretation of the arbitration clause, which was towards the application of the latest version of institutional rules, because the claimant failed to make any references or any statements in furtherance of their deviation from the model clause during the negotiation stages.
Counsel, I'm sorry. Counsel, does the contract have an entire agreement clause?
Madam Arbitrator, this contract merely mentions the word terminated in the preamble of this clause. And I would request this tribunal to not treat the word terminated, as merely having an effect of not continuing the intention, as the usage of the word terminated in the preamble of the clause establishes parties' unequivocal intention to terminate the preceding contract.
But Counsel, I read Article 2.4, and that seems to me, at least, it's a bit badly drafted, like many terms of the contract. But that reads to me as if it were to mean an entire agreement clause.
Members, I would like to invite this tribunal the preamble of the clause in the page 10 itself, where you are finding Article 2.4. In the fifth line from the top in the preamble, if the tribunal could read with me, the agreement replaces the earlier agreement between original parties, which is hereby terminated. Members, this usage of the word terminated establishes parties' intention of novating the contract and giving an effect of entire agreement clause. To substantiate the same, I would like to highlight the case of Must Holdings versus Astra Asset Management Company, wherein England and Wales Court of Appeal held that strict wordings must not be used for an entire agreement clause, and indicative words such as terminated can be given the effect of constituting novation.
So is it your position then that anything that's prior to this contract, including your predecessor's expression of their keenness to adopt the earlier version of rules, is something that the tribunal should not be looking at? Is that your position?
Precisely, Mr. Arbitrator. That is our contention here today. That the tribunal should not rely on the claimant Exhibit C7, that is the letter by Ms. Goble, and the intentions of Ms. Goble and Botanical Garden.
And you base that argument on the preamble of the contract?
Indeed, Mr. Arbitrator, because the parties have terminated the preceding contract. Additionally, the respondent did not even have knowledge of such intention while agreeing to the clause and the contract. This concludes my first prong, and now I would like to start with the second prong, that is the arbitration commenced in 2025. Members, both the institutional rules, that is SIAC rules 2025 and 2016, expressly entails that the date of commencement of arbitration shall be the date on which a notice of arbitration is received by the registrar of SIAC. And as for the lex arbitri in the present case, it entails that the date of commencement of arbitration shall be the date on which a request of arbitration is received by the respondent. Members, the claimant in the present case stands in violation of both the institutional rules as well as the lex arbitri by stating that the arbitration commenced by a notice of mediation in December 2024. However, a notice of arbitration was only filed in July 2025.
Sorry, counsel, if I can go back to the question raised by the tribunal and your answer as to ignoring all previous negotiations for the old contract. But then on question of interpretation in Article 8 of the Code, you have to consider all the relevant circumstances. So wouldn't the relevant circumstances of this case include the taking over of the earlier contract and therefore the negotiations for that contract?
Madam Presiding Arbitrator.
That's a relevant context, isn't it?
Madam Presiding Arbitrator, indeed, the relevant circumstances must look before and after of the negotiation and the contract in 2022. However, in the negotiation histories were there before the contract concluded in 2022, towards which we were provided an email server of Botanical Garden. Members, Botanical Garden is a public company, and its email server contains a plethora of emails. And the claimant wanted us to find an email from that plethora of emails towards which we have no knowledge of its existence. Therefore, members and Madam Presiding Arbitrator, the core reliance should be on the intention of respondent at the time of contracting in 2022, and if we are to consider the relevant circumstances, it shall be around the contract in 2022.
Is it not the case, counsel, that your CEO was in fact quite closely involved in the arbitration agreement that was put into the erstwhile contract?
Mr. Arbitrator.
So surely he knew what was in there.
Mr. Arbitrator, it is mentioned in the case file that Mr. Albius was connected in the Botanical Garden. However, it is not mentioned in the case file that he was involved in the negotiations between the claimant and Botanical Garden. Seeing the running time, I would like to conclude with my first issue and request this tribunal to apply the SIAC Rules 2025 and hold that the arbitration commenced in July 2025. This brings me to the second issue to be dealt today. That is, the tribunal should order the disclosure of claimants' third-party funding agreements. Members, the tribunal is very empowered by both the institutional rules as well as by the confidentiality clauses present in this agreement. To highlight the specific rules, Rule 27F of SIAC Rules 2016, read with Practice Note 1 of 2017, and for SIAC Rules 2025, Rule 38.4 of SIAC Rules 2025. These rules gives this tribunal the power to order disclosure. However, the reasons for the tribunal to order this disclosure and exercise this power are multifold in the present case.
But that's only relevant in conjunction with the request for security for costs, isn't it? So are you now submitting a request for security of costs?
Madam Arbitrator, it is indeed a matter of security for cost in relation to disclosure. However, we also have other reasons as to why we will be needing a disclosure. And for the application of security for cost, it is our contention that a disclosure of the agreement with ATJ Financing and Litshore will help us to create a justifiable application for security for cost. Therefore, members, as on behalf of respondent, we assure you that as soon as we obtain a disclosure, you will see an application for security for cost.
Well, we consider that either you make an application for security for cost now, and we consider it, and make any necessary deliberation as to disclosure of documents. Otherwise, isn't this premature? We can take into consideration in due course when we consider the question of cost and apportionment. But why should we be really bothered about this at this stage unless you show us the necessity or the relevance?
Madam Presiding Arbitrator, seeing that my time is elapsing, I would request an extension of 30 seconds to answer your question and conclude my arguments. If Madam Presiding. Thank you, members and Madam Presiding Arbitrator. It is our contention that it is not a preliminary or premature security for cost application because it shall be seen in the light of the fact that claimant is going to be insolvent very soon, and in light of fact that the claimant's funder, that is ATJ funder, has denied to cover any adverse cost liabilities. Members, in such circumstances, it becomes pertinent for us to assess both of these agreements in forward to put a justified security for cost application, as this is a unique case where the funder benefits substantially if a favorable award comes, but however, absconds any liability if any contrary award comes. Seeing that my time has elapsed, I would like to conclude my arguments if the tribunal not me for any further assistance.
I have one final question on that. I have some trouble understanding why it's important for us or for you to see the terms of the funding agreement. If what you say is right, that the claimant is about to be insolvent, then are the facts surrounding that development more important to the tribunal in deciding any security for cause application rather than the terms of the funding agreement? And is the funding even relevant to the security for cause application?
Mr. Arbitrator, let me address that concern for you separately for both the agreements. As for the agreement with ATJ financing, an assessment of that agreement will help us to understand the future position of the claimant. As ATJ financing is known to take a part in the conduct of the arbitration, the funding structures between them will help us to understand the role of ATJ financing and the future position of claimant in the upcoming arbitration. And as for the agreement with Litshore, members, insurance policies denying to cover the claim at the last moment is a common problem, to which even claimant was a victim. Therefore, we need to study the exclusions of that policy and the coverage of that policy to determine how much security for cost we will be needing in this agreement. If that answers your question, Mr. Arbitrator, I would like to rest my submissions here.
Yes, thank you. Yes?
Thank you, Madam Presiding Arbitrator. Honorable members of the Tribunal and esteemed colleagues, good morning. To briefly reintroduce ourselves, my name is Olivia Stolzenwald, and together with my co-counsel, Paul Markwood, I represent Claimant, Orcus Worldwide Limited, in the present dispute. My opposing counsel has started off with the wording that this world evolves around dynamics. However, the arbitration world evolves around party autonomy, and in the present case, the parties have specifically agreed on the SIAC Rules 2016, and Respondent only wants to apply the 2025 rules as it deems their threshold to be advantageous to its disclosure request. Now, mirroring my opposing counsel's structure, I will first address why the SIAC Rules 2016 apply, and second, why this tribunal should deny Respondent's request for disclosure of claimant's third-party funding agreements. Coming to my first submission, I would like to point out Rule 1.5 of the SIAC Rules 2025 that expressly allows parties to choose their own set of rules. And the parties in this case have chosen the SIAC Rules 2016. My opposing counsel has pointed to the arbitration agreement on page 13 of the case file, and my opposing counsel has stated that the parties have agreed on the current SIAC rules. However, contrary to my opposing counsel's submission, it is claimant's submission that this wording means the SIAC rules current at the time of contracting. My opposing counsel has also correctly pointed to Article 8 CISG as the relevant interpretation standard. However, as the parties have not individually negotiated the arbitration agreement, we will not pursue under Article 8 per subsection 1 a party intent, a subjective test, but we will pursue the understanding of a reasonable person of the same kind as the other party under Article 8 subsection 2. Therefore, we must step inside claimant's shoes and how claimant assesses respondent's behavior.
Counsel, you heard Madam Presiding Arbitrator invoke Article 8, para 3 of the CISG that we should consider all the circumstances of the case. And you heard me ask opposing counsel about the entire agreement clause in the contract. And my question is, wouldn't that entire agreement clause not exclude any consideration of the circumstances under Article 8.3 of the CISG?
Indeed, Madam Arbitrator, Article 8, subsection 3 refers to all relevant circumstances. However, as pointed out by the CISG Advisory Council Opinion number 3, also an entire agreement clause must be assessed looking through the lens of Article 8 SIAC and looking at all relevant circumstances.
That opinion has been very much has been criticized in literature, actually.
Indeed, Madam Arbitrator. However, even when we look at the entire agreement clause, the entire agreement clause, if I refer to the preamble, was especially inserted by the parties during the renegotiation process. That is true.
Well, I would like you to look at Article 2.4 of the contract. For me, that is what the parties intended as an entire agreement clause, not probably the preamble.
I understand, Madam Arbitrator. However, Clause 2.4 expressly refers only to the sale of goods and the purchase of goods. And furthermore, it is only in the section that is entitled Sale and Purchase. Therefore, it should only relate to the sale in the sense that the CISG and this agreement shall be the only rules applicable to the sale of goods. But for the arbitration agreement, still we can have party autonomy and we can have the party's choice.
But, Counsel, it's not a separate arbitration agreement. The dispute resolution clause is part of the sales agreement, and the title is sales agreement. So I cannot follow your distinction that we should apply different rules or that we cannot apply Article 2.4 to the interpretation of the dispute resolution clause.
I understand, Madam Arbitrator. However, also for the arbitration agreement, this tribunal should note that it is a verbatim adoption of an earlier agreement. And therefore, to understand it correctly, we must have access to the drafting history of the drafter of the arbitration agreement, which is a third party in this present proceeding that was later taken over by Respondent. And even when the parties inserted Clause 2.4, which was already on the template of Claimant and not expressly added by the parties in the renegotiation process, we must still relate to all relevant circumstances under Article 8 CISG. And my argument on why the parties chose the SIAC Rules 2016 bases on two limbs. First, that the current...
Before you go there, if I may, can I ask, is it your position that Clause 13 is ambiguous in its wording as it currently stands, and which is why we need to go back into the correspondence in the history? Or is it your position that the wording of the clause is clear that the 2016 rules apply? Which one is it?
It is my submission that for Claimant, the wording of the arbitration agreement was always clear, as it comes from an earlier contract. And when we look at Respondent's conduct, it was clear for a reasonable person in Claimant's shoes, or such reasonable person would understand, that Respondent, when agreeing to the very same wording of the current arbitration rules, Respondent also meant to agree to the meaning of the current arbitration rules, pointing to the SIAC Rules 2016.
So there is no ambiguity according to you?
There needs to be at least a little bit of ambiguity as we are here to discuss it. However, it is Claimant's contention that Respondent now only uses this as a shield and uses Clause 2.4 as a shield to not have access to the drafting history of the arbitration agreement, which is what we hold against Respondent, as Respondent's conduct left an impression of continuity on Claimant. Respondent, when taking over the botanical garden, stated that it wanted to take over all its commitments and liabilities, which in Respondent's own words, naturally included the sales agreement with Claimant. Respondent left Clause 15 completely untouched and always referred to an original contract that should be amended or modified. Respondent, in its own words, wanted to merely intensify the cooperation between the parties and increase the size of the contract. Therefore, it left an impression of continuity on Claimant, which Claimant and a reasonable person in Claimant's shoes can only understand as Respondent wanting to agree to the same meaning of the current arbitration rules that was loaded onto this wording in between the arbitration agreement of Claimant and the botanical garden. And therefore...
I can, for a moment, go back to the question that the learned co-arbitrator posed to the opposing side. Apart from the issues concerning disclosure of the third-party funding agreement, which I'm sure you'll get to in a moment, what's the difference? Which set of rules apply as far as the tribunal is concerned, or in your view, What is the difference?
The argument is twofold here. First, to honor the parties' agreement, and second, as the 2016 rules have a lower threshold for the disclosure.
Yes, so putting that aside for the moment on the disclosure requirements, what other fundamental difference in your view is important for the tribunal to consider?
When this dispute is conducted under the SIAC Rules 2016, there might be future procedural issues that should be treated under the SIAC Rules 2016 as well, and not under the SIAC Rules 2025. As an example, when there is a procedural order or another procedural motion that does not contain the disclosure of the third-party funding agreement, but maybe of another document or another inquiry that this tribunal would want to do, the threshold is different under the 2016 rules, and therefore, as the parties have also specifically agreed on them, the 2016 rules shall apply to the present proceeding. And this brings me to my second submission, namely that this tribunal should not order disclosure of claimants' third-party funding agreements. My opposing counsel has merely addressed the 2016 rules, so I will go first with them and then later come to the 2025 rules. Under the 2016 rules, my opposing counsel has addressed Rule 27F. Rule 27F of the SIAC Rules 2016 is a broad document production rule that allows disclosure where disclosure would be relevant to the case and material to its outcome. This double test of relevance and materiality stems from the IBA guidelines on taking evidence. And here the test was designed especially to prevent phishing expeditions into documents. A document should not be disclosed in order to find a claim, but only an existing claim should justify a document production. And in the present case, my opposing counsel has relied on the hypothetical claim that it hypothetically wants to apply for a security for costs. And this is standing opposed to claimants' two very legitimate interests in confidentiality of the agreements. First, I would like to point out to this tribunal that a security for cost order has traditionally two alternative leeways. First, to post money into a bank account, and second, alternatively, to conclude a mandatory ATE insurance. And in the present case, claimant has already voluntarily and diligently concluded an ATE insurance with Litcher, who has, as pointed out by this tribunal in this procedural order number 2, a very good market reputation, therefore ensuring compliance with an adverse costs order. And second,
I can interrupt you there. Is your position that Rule 27F the only provision under which we as the tribunal could order disclosure of the funding agreements? And secondly, is it not the case that you intend to seek from the tribunal orders in respect of the costs of the funding in this arbitration?
Yes, Mr. Arbitrator, pardon me. To just clarify onto your question, do you mean 27F as the only rule under the 2016 rules, or as opposed to the two? Yes,
under the
perfect. It is our contention that Rule 27F under the SIAC Rules 2016 is the document production rule, and as the third-party funding agreements are documents, this should be the specific rule that this tribunal should consider. However, even if this tribunal would like to see another rule, maybe Rule 19.1, which gives this tribunal a very broad power to conduct these proceedings, can maybe give this tribunal as well the power to disclose.
Why not the practice note of 2017?
I understand your concern. I would like to point here not only to the Rule 2 of the SIAC Rules 2025 and 2016 that contain the definition provisions, but also to the case of Spears, a 2020 case judged by an SIAC tribunal, in which it is expressly laid out that the practice note cannot empower the tribunal, but only serves as a mere guideline when interpreting the SIAC provisions. And therefore, we must turn to Rule 27F in the present case. For the reimbursement of funding cost claim that you have invoked as well, Mr. Arbitrator, this mainly concerns the ATJ funding agreement, as ATJ funding is the third-party funder of claimant covering the legal costs of these proceedings. And it is important here to note that in any event, if such a claim is risen, it would be claimant who would need to substantiate its costs. And claimant has also only reserved a claim for reasonable funding costs.
But surely the respondent must know what those costs are going to be and on what terms they are being incurred.
Indeed, Mr. Arbitrator. As I have a quick view on my time, might I have an additional minute to answer and conclude? Thank you very much. The extent of the reimbursement claim is not at issue right now, as it will only be a hypothetical claim in the future, and therefore, as respondent would also gain a procedural advantage when looking at claimant's third-party funding agreements, disclosure should not be ordered. Why does respondent get a procedural advantage? This is because the third-party funding agreements contain claimant's arbitration budget, and the financial terms and conditions might allow respondent as well to view how claimant assesses the merits of this case. This could be used to draw out the procedural fight, dry out claimant's budget, and push it into settlement negotiations using the assessment of the merits contained in the arbitration in the third-party funding agreements as a sword of Damocles in settlement negotiations. And as I have a look on my time, I would just like to quickly point out under Rule 38.4 of the SIAC Rules 2025, this tribunal should proceed with a balance of interests when it comes to disclosure, and as respondent would gain a procedural advantage from disclosure, the interest should be in the interest of claimant. Therefore, to conclude, disclosure should not be granted. Thank you.
Thank you. Do you have any other questions? Shall we move on to the
Yes.
Yes.
Members, if I may. The counsel for claimant mentions our case and our demand as hypothetical. However, it is also true that in light of claimant's insolvency, the agreement with ATJ Financing does not contain any settlement thresholds, which puts ATJ Financing, a rough funder, in a position to put as much money as he wants in this arbitration. This weakens the stance of respondent and creates a chance of exploitation, therefore necessitating such disclosure.
Yes.
Thank you. To clarify, claimant is only solvent until June 2026. However, claimant does everything in its power to not get insolvent. And second, exactly because claimant is only solvent until June 2026, claimant has concluded the ATE insurance with Litcher that should cover any adverse costs. And even when turning to the reimbursement for funding costs claim, I can only restate that such claim is reserved by claimant, and if raised by claimant, it would be claimant who needs to substantiate its costs. Thank you.
All right. Thank you. We can now move on to the merits. And again, do we start with the respondents?
No.
The claimants? Sorry.
Thank you, Madam Presiding Arbitrator, honorable members of the tribunal, esteemed colleagues, good morning. My name is Paul Marquardt, as earlier introduced by my co-counsel, and I will now turn to the merits of this case. Members of the tribunal, force majeure provides a shield for the diligent, not a sanctuary for the complacent. As early as September 2023, the Standing Committee of Sides recommended the reclassification of the vanilla orchid, including its immediate implications under Resolution 20.8. Only half a year later, on 1st of February 2024, this decision was confirmed by the Conference of Parties. Respondent's declaration of non-performance thereafter, on 10th of February 2024, was the inevitable consequence of its own passivity, leaving claimant with no chance but to conclude a cover sale with Herbal Cosmetics on 15th of February 2024. Against this backdrop, claimant wants to make two submissions today. First, respondent is not excused by force majeure, and second, the damages claimant consequently suffered amount to a sum as high as $3.3 million. starting with the force majeure excuse. Members of the tribunal, we are here today because it is Respondent who breached its contractual obligation to take delivery of the vanilla orchids. And the only relevant question is whether that breach can be excused by the alleged insurmountable nature of the surrounding events, or in other words, by force majeure. And to assess that question, we would first have to set the correct standard. Although Article 79 CSG provides the default rule for force majeure, the parties to this proceedings agreed on a specific, on their very own force majeure framework in Clause 12 of the sales agreement, as it can be found on page 13 of the case bundle. If the tribunal would like to follow me on page 13. We are looking once again at the sales agreement of the parties, Claimant's Exhibit C3, and I'm referring, as mentioned, to Clause 12, which headline reads force majeure. Clause 12.1 then goes on, and I quote, "A party is not liable for failure or delay caused by events beyond its reasonable control," end of quote. It then provides a list of examples where such an event is rebuttably presumed. But crucially, Clause 12.2 furthermore imposes an obligation to mitigate the resulting effects. And as those criterions of Clause 12.1 and Clause 12.2 are cumulative, Respondent's reliance on force majeure fails if claimant proves that only one of them is not met.
Counsel, I read Article 12 of the contract, and I see the differences to Article 79 of the CISG, whereas the CISG, additionally to impediment beyond the control, mentions foreseeability and avoidability. This clause doesn't mention either of them. So it only mentions impediment, or what does it say? Events beyond its reasonable control.
Indeed, Madam Arbitrator, Clause 12 does not include a foreseeability at time of contracting criterion. However, on this criterion, the case does not turn. However, Clause 12.
But it turns on avoidability.
However,
and avoidability is not mentioned here either.
However, Clause 12.2 imposes an obligation to, and I quote, use all reasonable endeavors to mitigate the resulting effects, and this is the technical equivalent to the avoidance and overcome criterion of Article 79 CSG.
To mitigate the effects, but not to mitigate or to avoid the event itself.
It is not claimant's position in this proceedings that Respondent could have avoided the impediment itself, but it could have avoided the effects of this impediment by two measures. It could have first accepted earlier delivery of the vanilla orchids, or could have secondly applied for an anticipatory import permit. And both of those measures for themselves would have saved the transaction in this case, starting off with the acceptance of earlier delivery. By January 2021, already one of three new green vanilla greenhouses was fully operational, and the remaining 2/3 of the vanilla orchids could have been planted in older, already existing greenhouses on an interim basis. This was a pressing issue because international regulations such as CITES are highly political, and they are shaped by unpredictable multilateral negotiations. So the referral of a matter, for example, from the Standing Committee to the Conference of Parties is already a red flag. Latest from that point on, every responsible business person would take all reasonable endeavors to be prepared for any outcome of those proceedings. And such an early delivery was an option here, as it is undisputed between the parties. The only relevant question is whether it would have been reasonable for a Respondent. And as planting 2/3 of the vanilla orchids in older greenhouse potentially bore the risk of higher energy costs, an increased loss rate, and higher additional transportation costs. Only the latter in this case constitutes a significant hurdle, because the vanilla orchids could have been replanted to the new greenhouses once they became fully operational in March 2024. So higher energy costs would have been strictly limited to a 2-month period, and the also within the case bundle mentioned higher loss rate would not have materialized, as it is expressly limited to a scenario in which the orchids remain in the old greenhouses. The only actual obstacle were the additional transportation costs of around $50 per orchids, a total sum not higher than $165,000, mere 2.5% of the total contract value. In case law, in similar cases, has established that even cost increases up to 100% of the total contract value, for example in the Turkish Indian sales case, are still considered reasonable to mitigate the effects of an impediment. And compared to these thresholds, a cost increase of mere 2.5% appears like a negligible sacrifice which Respondent was contractually obligated to make. And that was not the only option.
I can just interrupt you there. Apart from the issue of the costs, is it also not extraordinary that the change or the movement from Appendix 2 to Appendix 1 being immediate is unprecedented? And surely they couldn't have possibly taken that into account, and a reasonable person would assume that they had the 90-day window, and that would have been well within the delivery window. Why is that unreasonable or not what a reasonable person would do?
Indeed, Mr. Arbitrator, this is quite unusual, and it was actually the first time ever in the history of SIAC that this took place. However, I would like to direct the Tribunal's attention to page 14 of the case bundle. We're now looking at a newspaper article from 2nd of February 2024. And I'm quoting from the first column, second paragraph. If the Tribunal is with me. So first column, second paragraph, there it reads, and I quote, "It thereby followed the recommendation of the Standing Committee from September last year, including the use of the new powers under Conference Resolution 20.8 to make amendments with immediate effects." So already from September 2023 onwards, it was clear that if the vanilla orchid would be reclassified, this would have immediate effects. And Respondent had a second alternative to prepare for that, and this one might be of even more relevance. Respondent could have applied for a so-called anticipatory import permit. Such a permit has been granted by Equatorianian authorities before and would have allowed Respondent to take delivery of the vanilla orchids independently of the final site's decision. That would have come with a minimum of additional effort only, as Respondent was contractually obligated to organize the import anyway. All it would have taken in the present case to render the site's decision a mere footnote to this transaction was to file an application a few weeks earlier than actually done. And considering what was at stake here, the total contract survival, Respondent's unwillingness to incur minor additional cost increases or to undertake any additional effort constitutes a manifest breach of its obligation under the clause 12.2. Hence, Respondent is excluded to rely on force majeure. And with that being said, I would come to Claimant's second submission today, which is...
Before you go there, can I ask, what date do you say the Respondent breached the contract? What's the relevant date according to you?
Respondent breached the contract on 10th of February with an anticipatory breach because on that date, Respondent announced that it would not take timely delivery of the vanilla orchids while time was of the essence under the sales agreement. So Claimant's damages amount to a sum of $3.3 million, and this quantum bases mainly on two factors. First, a price difference of $1,000 per orchid, and second, a quantity of 3,300 vanilla orchids. Members of the Tribunal, let us examine the price difference first. Being left stranded with highly perishable vanilla orchids, who would lose at least 30% of the value after their first flowering in the summer of the same year, and the closing delivery window in May 2024, Respondent urgently reached out to Herbal Cosmetics and concluded a cover sale over those orchids with delivery in May 2024, on 15th of February. So, respondent in the proceeding has always argued that claimant is excluded to rely on this cover sale for one single reason. It concluded it a few weeks earlier than it formally avoided the sales agreement between the parties. However, it has been established by case law and by scholars that an exemption from Article 75 has to be made when the other party has already made clear that the contract came to an end. Courts argue that it would be pure formalism to require formal avoidance in the first place if the other party has already abandoned the contract. It would...
But, Counsel, if we were to stick to the wording of Article 75, is there any other provision you are relying upon for the damages regarding the cover sale?
So even in this scenario, the tribunal would not accept this exception made by scholars and by case law. We would fall back to the more general provision of Article 74 CRSG. And under this provision, we would have to ask the question, what was claimant's position before and after respondent's breach of contract, leading to the very same result, because before the breach of contract, respondent sold 3,300 vanilla orchids for an amount of 6.6 million US dollars. And after
I understand that your client does not want to open its books. So if we were to rely on Article 74, it would have to open its books. Because under Article, well, who has the burden of proof regarding the amount of loss incurred?
Indeed, Madam Arbitrator, it is held in the procedural order number 2 that claimant does not want to open its books. However, under a calculation of Article 74, no additional information would be needed than those which are already known to the tribunal. We only have to assess claimant's position before the breach and after the breach, and for both we have all the relevant information. So, if I may ask for an additional minute to conclude my submissions, members of the tribunal?
All right, yes.
Thank you. So this would lead me to the second main factors of today's pleading, which is a quantity of 3,300 vanilla orchids. Members of the tribunal, the parties in this case, agreed on the sale of around 3,000 plus minus 10% vanilla orchids. And they did so as a safeguard against mutual risks, mainly the failure of the orchids to survive, and second, insufficient transport capacities. So this variation on quantity was intended as a safeguard against negative risks only, and it has to be interpreted accordingly as an exclusive negative adjustment mechanism, meaning the parties agreed on the sale of the maximum amount of 3,300 vanilla orchids, which however could be reduced as far as one of the before-mentioned risks materialized, but never below a quantity of 2,700 orchids. And in this case, none of these risks ever materialized. In fact, claimant was able to produce even more than 3,300 vanilla orchids, and respondent never make any attempt to organize the transport of the orchids. The parties, however, never intended this variation as a leeway from liability in case the sales agreement should fail, wherefore any attempt in this direction must be rejected. And as far as I can't be of further assistance to this tribunal, this would conclude claimant's submissions. Thank you.
Yes, thank you. Yes, sorry.
I have one final question, which you can hopefully quickly address. Are you also all right, as an alternative for the tribunal, to use the market price of the orchids as of 10th February, which is the date of the breach, according to you, as a measure of the damages?
It is true that under Article 76 CRSG, the damages can also be calculated under the market price. However, under the CRSG, the concrete calculation of damages has a priority before an abstract calculation of damages. And it is, for example, held by Professor Schlechtriem that in case like ours, where the calculation cannot be made under Article 75, the aggrieved party has a right to choose whether it wants to calculate its damages under Article 76 or 74. In this case, claimant chooses Article 74.
Yes?
Members. Members of the Tribunal, Counsel for Claimant, and all my colleagues present. Good morning. As introduced by my co-counsel, I am Soumya Jain, and I will be dealing with the substantive part of this dispute on behalf of Respondent, Darwin Natural Foods PLC. Members, this dispute is about power and prejudice. Power that government of Equatoriana had, and prejudice that Respondent will face by unjustly enriching Claimant. In this regard, I will be making two broad submissions by mirroring Counsel for Claimant submissions. First, that Respondent is excused from any liability. Second, in any case, Claimant's claim for damages is not sustainable. Proceeding to my first submission. Members, allow me to correctly address the threshold that needs to be put in order to determine whether Respondent is exempted from any liability. Counsel for Claimant has incorrectly stated that Clause 12.1 completely displaces Article 79 CISG, and it is Respondent's contention that the essentials of Article 79 CISG should be indeed used as the guiding principles in order to determine whether Respondent is excused or not. Accordingly, my first submission has three legs. First, the impediment was unforeseeable. Second, it was unavoidable. And third, it was beyond Respondent's control. Proceeding to the first leg of my submission. Members, going by the bare words of Article 79 CISG, foreseeability.
So, Counsel, you're starting with Article 79. You're not starting with the contract. So 79 prevails over the contractual agreement of the parties.
Members, it is Respondent's submission that Clause 12.1 and Article 79 should be read in tandem, and hence the essentials of Article 79 are implicitly mentioned in the clause itself.
Or are you accepting that the contractual clause of force majeure does not even apply or does not extend to the facts of this case? Are you accepting that?
Madam Presiding Arbitrator, I'm not accepting that Clause 12.1 does not apply. All I'm saying is that there should be harmonious construction between the both. If I can now proceed to the first leg of my submission. Members, foreseeability is only determined by what was known or ought to have been known by a reasonable party during the time of contract conclusion. Now, in the present dispute, the contract was concluded on 25 August 2022. And even the remotest seeds of the impediment arose in September 2023, that is 13 months after contract conclusion. Accordingly, the impediment was indeed unforeseeable to Respondent.
So what exactly is the impediment?
Madam Arbitrator, the impediment in the present dispute has a conjunctive nature. Both the uplisting of vanilla orchids from Appendix 2 to Appendix 1 of the CITES Convention with immediate effect, along with the sudden change in government of Equatoriana's stance relating to issuance of import permits, conjunctively constitute the impediment. Now, if I can now proceed to my second leg of my submission, that this impediment was unavoidable. Counsel for Claimant suggested two methods to avoid the impediment, that is, an anticipatory import permit and an early delivery. I submit both are unreasonable. First, if I can quote Article 7, Paragraph 4 of the CITES Convention itself. Specimens of animal species included in Appendix 1, bred in captivity, or specimens of plant species included in Appendix 1, artificially propagated for commercial purposes, shall be deemed to be included in Appendix 2. End of quote. Now, members, since the subject matter of the contract were indeed vanilla orchids that were artificially propagated for commercial purposes, it was fairly reasonable of Respondent to infer that even if the parent vanilla orchid is uplisted, the subject matter of the contract is still governed by Appendix 2, hence having no import permit requirements. Now, if I can address the concern relating to an early delivery. Counsel for Claimant has again incorrectly stated that the threshold of commercially impossibility is 100%. Respondent is not claiming an exemption of financial hardship. Respondent is merely contending that taking an early delivery would be commercially imprudent under those circumstances. In this,
But you allege that it would be unreasonable to incur these further costs, and Counsel for Claimant told us it's just the additional costs for transportation. So what is your suggestion on this?
Certainly, Madam Arbitrator, allow me to alleviate that concern. In these circumstances, the reasonable expectation test opined by CISJ Advisory Council in its opinion number 20, paragraph 7.4 is of special importance. In that test, the Advisory Council opined that if the reasonable expectations of any business person in a contract are breached beyond the limit of sacrifice, a party can indeed be relieved of its contractual obligations.
What are the additional costs that your party will have to incur or would have had to incur?
Madam Arbitrator, taking an early delivery would have required respondent to place 2/3 of the vanilla orchids outside in extremely unfavorable circumstances. Furthermore, if the tribunal can now kindly follow me to page 57 of the case file. Procedural order 2, clarification number 15.
57?
Yes, Madam Arbitrator. Can I now proceed? If the tribunal can read the third and the fourth line with me, herein it is clarified that
What number? 15.
Clarification number 15, Mr. Arbitrator.
15?
Yes. Herein in the third and the fourth line, it is clarified that the transportation cost would be twice of 50 USD per orchid, hence hundreds and thousands of dollars in transportation cost alone. Furthermore, if the tribunal can read the bottom third line with me, energy cost would be thrice compared to new greenhouses, with a risk of complete total loss in adverse weather. Now, members, when at that time the impediment was not completely cemented or materialized, it was completely unreasonable for claimant to expect that respondent should incur all of these additional costs. Accordingly, I submit that the impediment was unavoidable. Now, if the tribunal can stay with me on the same page and come to clarification number 17. Clarification 17, I read the first line. On 5 February, respondent did apply for an import permit, but it was rejected by the relevant Ecuadorian authority. Now, members, any commercial party cannot be expected to enter the door when the state holds the key and refuses to turn it in. Under these circumstances, Article 79 does provide refuge, and hence respondent is indeed exempted from liability. This brings me to my second submission, that in any case, even if we take claimant at their best, their alleged cover sale does not fulfill the threshold of Article 75, and they should not be awarded any damages. Here I have
one question to go back to your point about the nature of the goods that you were purchasing under the contract. You said some of it is, or most of it is artificially propagated and it should be under Appendix 2. Is it your position that the claimant misrepresented the nature of the goods, or that there was a mistake as to your understanding as to the nature of the goods you were purchasing under the contract?
Mr. Arbitrator, you're indeed correct. In Procedural Order 2, clarification number 3, it is clarified that claimant had a grave fallacy in its production process for the 2024 batch of orchids which respondent intended to buy. Claimant did not mark the goods properly as to which were artificially propagated and which were wild orchids, and never notified the respondent about the same. Accordingly, claimant did misrepresent the quality of goods that respondent intended to purchase. If I can now proceed to my second submission. Members, any claim for damages is something that compensates the counterparty, it is not a mechanism to claim additional profits. But that is precisely the present case. In the present dispute, in my first point, I submit that claimant made a profit in the cover sale. Now, the notice of avoidance between the parties is the actual point wherein the contractual relationship is terminated, and after that, a party is free to sell those same goods to any counterparty. And the facts also lead to the same conclusion. If I can draw the tribunal's attention to page 39 of the case file. Respondent Exhibit R3, email from claimant to respondent dated 1st of March 2024, and the subject of the email is avoidance of agreement. Herein, two concerns are to be clarified from paragraph number 2 and 3. First, claimant's statement in paragraph number 2 reads, and I quote, "On 27 February, you informed Mr. Harmon that Darwin Natural Food will not fulfill its obligation under the agreement and take delivery of the vanilla orchids," end of quote. I agree that respondent did constitute non-performance. But the relevant date is 27 February and not 10 February as counsel for claimant suggested, which is clarified by claimant's own written submissions. And in paragraph number 3, I quote, "Orchards will try to sell the vanilla orchids which have been reserved for you to another entity as soon as possible." Claimant's own written submissions on 1st of March indicate that they will conclude the cover sale. This, in addition to the fact that claimant is not willing to open its book of accounts to establish damages, and claimant has not established any documentary evidence in its notice of arbitration to actually establish that a cover sale did take place on 15th February, I submit that that cover sale should not be considered.
You heard my co-arbitrator ask the question to counsel for claimant whether they could be happy with the market price at the time of the avoidance of the contract. So would that be agreeable to you as damages, the market price rule?
Madam Arbitrator, allow me to address that concern in two parts. First, Clause 9.2 of the sales agreement displaces Article 74 along with Article 76 of SIAC. Second, even if those mechanisms were deemed applicable, any mechanism for damages should not be used to give profit to the counterparty. And now I will establish that claimant made a profit in the cover sale. As claimant's own submissions on 1st of March indicate that...
Why would the market price be a profit for claimant?
Madam Arbitrator, because the relevant cover sale is the cover sale concluded on 2 of October. Because 74 and 76 articles are displaced by Clause 9.2 of the sales agreement, in addition to the fact that claimant is not opening its book of accounts. And on the cover sale dated 2 October, claimant made a profit of $1 million. Accordingly,
claimant was dealing in goods of the kind all the time, so I cannot see why they made a profit in October.
Madam Arbitrator, in the contract between claimant and respondent, claimant was entitled to sell 2,700 orchids at a price of $2,000 USD per orchid. And at the same time, in the cover sale concluded on 2 of October, claimant sold 2,000 orchids at a price of 3,200 USD, which was the market price at that time. Accordingly, when we subtract both of these values, we get a profit of $1 million.
If I may, I don't think the question is about the market price in October. The question is about the market price at the date of the breach that is being alleged, which according to the claimants is 10th of February, which according to you is, I think, 27th or so of February. So I think the question is, can the tribunal use that date and the market price as of that date to assess the damages that are due to the claimant?
Mr. Arbitrator, I respectfully submit that the tribunal should not, and there are two reasons for the same. First, claimant did not conduct its cover sale as a reasonable, prudent business person, which is the relevant standard. Claimant...
Well, if we were to apply the market price rule, it's not a question of a cover sale.
Madam Arbitrator, but even then it is the question of whether the goods were actually a substitute goods or not. But in the present dispute, claimant adjusted the alleged cover sale in a pre-existing business transaction, and that also excludes the market price concern that the tribunal has. Now, seeing the paucity of time, I would like to request an extension of 30 seconds to conclude my submissions. Members, this brings me to the last point, that respondent had the right to determine the exact quantity of orchids. Counsel for claimant has incorrectly stated the intention behind the quantity tolerance clause. The quantity tolerance clause was indeed added for natural production variations, but at the same time, it was also added to deal with transportation problems because vanilla orchids are highly sensitive to transport. And since respondent had the duty to transport all those orchids, it naturally entails that respondent also had the right to determine how much orchids it can transport. Furthermore, claimant generally loses 10% of the orchids. Accordingly, parties' intent at that time should be 2,700 orchids, which in any case makes claimant's claim for damages under Article 75 incorrect. Here, I rest my submissions, and I thank you.
Yes.
Thank you, members of the tribunal. Opposing counsel relied to a different transaction, an option with exercised by Herbal Cosmetics on 2nd of October 2024 as the relevant cover sale. However, one point in this regard. This option was granted by Claimant and therefore became binding for Claimant also on 15th of February 2024, the exact same day the actual cover sale was concluded. So by raising this argument, opposing counsel effectively acknowledges that taking action on 15th of February was justified. However, the only relevant difference between both transactions is that only the transaction with delivery in May and a loss of $3.3 million dealt with those orchids Claimant was left stranded with. Thank you.
If I may, members of the tribunal.
Yes.
CISG compensates loss, not disappointment, and certainly not profit. Selling the first offer, even the alleged offer, in cases of a question is not mitigation, it's panic. Now, Claimant itself has incorrectly understood Respondent's submissions. I clearly established that Respondent is contending the cover sale to be on the later date. And in any case, the alleged cover sale should not award any damages because a contract should not be reinterpreted with the benefit of hindsight. Thank you.
Thank you. Oh, do they have additional? No, that's it. So we can deliberate. Right. Thank you for your submissions. We will be deliberating on your submissions.
Thank you.
We thank the tribunal for their challenging round, and we ask that the tribunal and the council both remain on stage for a moment for a photograph.
So I think we sit. Shall we sit? Or? Yeah.
Now, the tribunal will retire to deliberate, after which they will join us, please. We'll ask the tribunal to join us for the group photo at precisely 12 o'clock. I hope that gives you time to decide. It may take a long time. The rest of us, the teams included, will proceed now to the site where we're going to take the photograph, which is upstairs in the garden. Some of you may want to change clothes or whatever. Please do it quickly. We want everybody there by about 11:40 so that we can arrange you for the photograph and take it at exactly 1 p.m. Okay, before you stand up, please allow the tribunal to move out of the room. And the second thing to do is pick up everything that you brought in, right? Pick it up. Have you got everything that you brought in your hands? Leave the table precisely as you found it. If you've moved the forks and knives, put them back where you found them. All right, we don't want the staff to have to reset the tables when you leave. And remember, you will not be coming back to the same place. You'll be coming back to your assigned tables at lunchtime. So please, now bring your things to the photo site and put them to the side so that they don't take up space. We have to get you as close together as possible. So you'll be following Maricel, who is in the red jacket there, one of us in the red jackets. Follow Maricel once the tribunal has left the room. They're just about gone. So I invite you now to stand and to proceed upstairs to the garden for the photo. And as I said, if you're not there at 1 o'clock, you won't be in the photo. It's 12 o'clock. If you're not at the garden in place at 12 o'clock, you won't be in the photo, so please do get there. That was really good. Well,
Nói gì à? Giá dền sao mà mệt á? Hả? 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 路哈哈哈，係咯，但係我呢？唔係喎，但係 A 一 B 路哈哈哈。 咦？係啦，啊！但係想解返佢。路，呵，我淹晒啦，淹咗啦，吓？乜嘢啊？我而家就係想解返佢咯，呵，一二，呵。
因為我叫佢飛，我叫佢拉低飛，我仲有聲出嘅會。
有。
俾你啦而家。使唔使咁大啊？路，呵，嘻嘻，路，呵，一二三，路。嘿，唔得，嘻嘻，嘻嘻，嘻嘻，我先咁講，嘻嘻。嘻嘻，嘻嘻，嘻嘻，嘻嘻，嘻嘻，嘻嘻 ，hello testing， 1、2、3、4，好 like， 嘻嘻。嘻嘻，嘻嘻，
支持。嘻嘻，嘻嘻，hello。嘻嘻嘻嘻嘻嘻嘻。嘻嘻嘻嘻嘻，冇埋聲喎。嘻嘻。哦哦哦哦。哦哦哦哦。 哦哦哦。
路呵呵，一二呵呵呵，一二三四，路一二呵呵呵，一二三。路一二，有着，都冇。路呵呵呵，擺低嗰兩。路呵呵。路呵呵。路呢個咯，哦哦哦。哈哈。嘻嘻，嘻嘻。 路呵呵呵，一二呵呵呵，路嘿嘿嘿，路呵呵呵，一二呵呵呵，一二三，路呵。路呵呵呵，一二三四，路路一二呵呵呵，路呵路呵呵，路呵呵。哦哦，哦哦哦，路哦哦，路哦哦哦。路一二三，哦哦。 lo, ho, ho, lo, ho, 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 ho.冇聲噶嘛，但係佢都仲有噶。
Test 1 2. Test 1 2 有啊，照有啊。Test 1 2係啊，你都有啊。
Ladies and gentlemen, these are assigned seatings. We are different from Vienna. We like to claim we are more organized, but I think we're just more OCD. So, if you don't know where you're sitting, please go take a look at the seating chart that's outside the Brand Ballroom, or you can ask one of the helpers. Also, for those of you who are wondering if you're going to get your correct dish, your food cards are on your table. So please make sure you take the food card that you chose and put it in front of you. For my final teams, you guys have your reserved seats, so you know where to go. If you do not have a ticket, or if you did not purchase a ticket, please go see one of the Vis East Moot administration and do not just sit down at a table, because we will know if you are out of place. And don't put me in that uncomfortable position where I have to call you out.
嗱，有啦。路。
Ladies and gentlemen, I said I did not want to have to call you out, but unfortunately that doesn't look like it's gonna not happen. If you have not purchased a gala ticket yet, and you are required to purchase a gala ticket, please come up to the corner over here so that we can sort you out with your tables. Please do not just sit down, even if somebody has told you to sit down. If you do not have a gala ticket, we need to organize you. So please come up to the front right up here.
Well, now that I've got your attention, welcome to the final awards gala lunch of the 23rd Vis East Moot. We're thrilled by the number of people that are here today, and I think that's a reflection of how much everybody enjoyed this week, including us, the people that have been trying to run around organizing it, but we're thrilled to have you all here and to see your smiling faces. I know you're waiting for the final results of the deliberations of the tribunal, but that's going to be dessert. So we'll be waiting for that, but we have many other things to do in between. Can I ask Lucy Reed, please, to join me on stage for a moment and greet us on behalf of SIAC?
Thank you, Louise. On behalf of everyone here from the Singapore International Arbitration Center, those who have been enjoying Hong Kong and the VIS, and others working back in Singapore and elsewhere, I want to make 3 points. All you Moody's know that's the maximum. The first is appreciation. We appreciate Sherlyn, Louise, Marichelle, all volunteers, all coaches, all arbitrators, all professors, all cheerleaders, and all handholders. My second point is congratulations. Advanced congratulations to the winner today, to the semifinalists, the quarterfinalists, and every single Moody here, because you are all finalists, because you started one day with the orchid problem last year, and you are here today. You are all finalists. My third point is a bit of advice. As you leave, this is for the Moody's, whom I also appreciate, of course. As you leave school and you start in practice, and maybe you start drafting arbitration clauses, I want you to think about current, then current, now current, for the time being in force. Who knows? Who knows? Maybe the 2045 SIAC rules will say, for an arbitrator to be appointed, he or she must have been a 2026 VIS participant. Thank you.
Now we're going to have a break in the proceedings to enjoy lunch, or parts of it, and throughout lunch, I'll be asking various people to come up and make some awards over lunch. So, bon appétit for now, and we'll be back later.
Hello everyone, my name is Arthur Ma. I'm a partner of Dahui Lawyers. I'm sending this message from Beijing on behalf of the law firm and also my partners Dai Yi and Lu Lele, who also sponsored this year's event. It is my great honor to celebrate the successful conclusion of VIS Moot Hong Kong 2026. Over the past days, we have witnessed exceptional advocacy, rigorous legal analysis, and the highest standards of professionalism from all competing teams. Congratulations on your outstanding performances. Whether you advanced to the final rounds or not, your dedication to mastering the complexities of international commercial arbitration is truly commendable. You have demonstrated not only the legal acumen, but also the cross-cultural collaboration skills essential for tomorrow's global dispute resolution practitioners. My sincere gratitude to my dear friends Louise and Charlene, the Vice Moot Association, the host institution, and the numerous volunteers who worked tirelessly behind the scenes. Your commitment ensures this competition remains the premier platform for nurturing future arbitration talents. As a firm, Dahui Lawyers is deeply committed to advancing international arbitration education. We proudly support the Vice-Moot East program through sponsorship, mentorship, and training initiatives, believing that investing strengthens the entire dispute resolution ecosystem. We look forward to continuing this participation in the years ahead. Thank you again and congratulations to all of you. Bye bye. 结束录像，停止录像。
Can I have your attention, please? We have our first award to give out, and it will be for the best memorandum for the claimant. And I'm asking Professor Jeff Wainsheimer to present that award.
Thank you, and good afternoon, everybody. This is called the Award for the Best Claimant Memorial, but having coached from the very first year of the Moot, I would call this the award for the team that overcame not knowing anything about arbitration, not knowing anything about the CISG, not knowing how to work in groups, and certainly having no one who volunteered to do the footnotes to come up with the best 30-page documents 5 weeks after starting this journey. So to those teams, I will now read out first the honourable mentions, and then I will do the second runner-up, the first runner-up, and the winner. And also, after 30 years of doing this, I know that law students are biologically programmed not to listen to instructions. And the instruction is this: in the honourable mentions, if you hear your name, enjoy it. Do not cheer, do not clap, do not go nuts, just enjoy it, because we get through a long list. The list is long and it's in no order. Honourable mentions before the 3 winners. First honourable mention, University of Helsinki, University of Ljubljana, O.P. Jindal Global University, School of Law, Christ, deemed to be University, Bangalore, Shanghai University of Political Science and Law, Loyola University, Chicago School of Law, Nagoya University, Freie Universität Berlin, Goethe University, Frankfurt am Main, Heinrich Heine Universität Düsseldorf, Hidayatullah National Law University, Raipur, Humboldt University zu Berlin, Leibniz University of Hanover, London School of Economics and Political Science, National Law School of India University, National Law University, Delhi, South China University of Technology, Southwest University of Political Science and Law, Team 790, University of Fribourg, University of Göttingen, University of Munster, University of San Diego, University of Tehran Institute of Public Law Studies, University of Vienna, WU Vienna, Albert Ludwigs Universität Freiburg, Charles University, China University of Political Science and Law, Damodaran Sanjeevaya National Law University, East China University of Political Science and Law, Fordham University School of Law, the British University in Egypt, the West Bengal National University of Juridical Sciences, University of Cologne, and last, China EU School of Law. Now you can cheer. And I call up the runners-up. Yeah? Yeah. And we can do one by one with a cheer and a clap, and you can come up here to receive a certificate. The second runner-up is the University of Zurich. Please come up. Where's Zurich? Back in Zurich? Okay. Oh, here they're coming. They knew they were winning, they dressed for the occasion. The first runner-up, Heidelberg University. They're coming here. And the winner of the David Hunter Award for Best Memorandum on behalf of Claimant, Nalsa University of Law. They're coming now. So I had. Okay. Go back to enjoying your food, and we'll have more awards to come.
May I have your attention, please? We have another award to present. And this award is for the best respondents memorandum, the Fali Nariman Award. I'm going to ask Eric Ng to come and present the awards.
Ladies and gentlemen, it is my distinct pleasure to announce both the honorable mentions and the award winners for the Fali Nariman Award for Best Respondent Memorandum. The Respondent Memorandum comes at a strange time in your lives. You will have spent time learning the problem and drafting your claimant memorandum, and you are probably in the middle of preparing your oral submissions. And yet you still have to provide this responsive memorandum, which requires a different set of skills, a different set of insight, and probably a lot more stress for everyone involved. As with the claimant memorandum, I will be announcing the honorable mentions first in no particular order. If you hear your name, please wait until all of the honorable mentions have been announced before we give a round of applause for everyone. So, in no particular order, honorable mentions are University of Ljubljana, Adam Mikovic, University of Poznan, Ludwig Maximilians Universität München, Singapore Management University, South China University of Technology, University of Turku, Heinrich Heine Universität Düsseldorf, University of Lapland, Albert Ludwigs Universität Freiburg, University of Tehran Institute of Public Law Studies, University of Zurich, Peking University, University of Warsaw, Nassau University of Law, Goethe University Frankfurt am Main, School of Law Christ deemed to be University Bangalore, Hanoi Law University, University of Göttingen, National Law School of India University, University of Eastern Finland, the Chinese University of Hong Kong, WU Vienna, Leibniz University of Hanover, National Law University Delhi, Peking University School of Transnational Law, University of Vienna, Team 904, La Trobe University, and the University of Helsinki. Ladies and gentlemen, a round of applause for all the honorable mentions. Now, I'm very pleased to announce the second runner-up. And could this team please come up to the stage to accept their prize? The second runner-up is the University of Mannheim. Now, let's come up here first. All right. Where's University of Mannheim? I see them. Now, this is a little strange. We do not have a first runner-up. Instead, what we have is a tie for the Best Respondents Memorandum. So I will be inviting two teams to jointly accept the Fali Nariman Award. Your joint winners of the Best Respondent Memorandum are Humboldt-Universität zu Berlin and Heidelberg University.
Humboldt.
Thank you. Thank you.
I have your attention again, please? We have another award to give out. And this award is for the best oralist in the competition. So this award is given out to the best oralist of all of those oralists who participated and argued on both sides, one for the claimant and one for the respondent minimum. Any other people that have higher marks but have not done both sides are not eligible. And to ask to present the award, I'm going to ask Neil Kaplan to come to this podium.
Thank you very much, Louise. May I add my congratulations to all of you for your outstanding work and for your great efforts in this wonderful competition. I hope you've enjoyed it as much as we've all enjoyed being part of it. Now, many people have a very difficult job to fulfill, but I think this is one of the hardest, because not only do I have to read out a lot of names, but a lot of universities that are quite difficult for me to get my head around. So if I mispronounce your name or your university, please don't take any notice of it. I don't intend any discourtesy. And can we please also apply the Waitsheimer protocol? No clapping until the end of the first, a lot of announcements, and then we'll do the other ones one by one. So here we go. Honorable mention, Lily Marie Therese Petterisch, Heidelberg University. Now. Alexis Hughes, University of San Diego. Andrea Polakova, Charles University. Akash Anand, Dr. Ram Manohar Lohia, National Law University, Lucknow. Anna Altenkirch, University of Mainz. Mei Xuan Tam, National University of Singapore. Danai Estrada, Universidad Panamericana, Guadalajara. Makina St. Amand, University of San Diego. Paul McCaw, Humboldt University, Berlin. Yu Ying Anthea Lee, the Chinese University of Hong Kong. Vivian Irene Mimura, Keio University Law School. Balint Scherbel, University of Vienna. Joel da Casa Garcia, Esada Law School. Lisha Mishra, Dr. Ram Manohar, etc., Lucknow. Natasha Tanzos, University of Vienna. Shenjin Chu, National Union of Singapore. Sean Marie Prythil Patnubai, Ateneo de Manila University School of Law. Anna Samatova, Team ID 894. Jan Kroner, Albert Ludwig Universität Freiburg. Abigail Brynensen, Cornell Law School. Garrett Buchler, University of Wisconsin Law School. Jacob Mertens, University of Mainz. Viraj Thakur, National Law School of India University. Devansh Anand Desai, O.P. Jindal Global University. Hon Ying Wong, Faculty of Law, University of Hong Kong. Gehansa Samarwika Erma, La Trobe University. Ruyi Liu, Shanghai University of International Business and Economics. Giska Bus, University of Münster. Ben Bargen, University of Cologne. Colin Zinker, University of Göttingen. Vinila Gottapalli, Damodaram Sanjeevaya National Law University, Iris Eliza Cohen, Keio University Law School, Isabel Varallo, La Trobe University, Sebastian Beck, La Trobe University, Yubin Lee, Peking University School of Transnational Law, Artu Jormaka, University of Turku, Sumya Jain, Hidayatullah National Law University, Raipur, Megan Tian, Peking University, Henrik Mathiasen, University of Southern Denmark, Danai Imriotti, University of Mainz, Emmett Hare, University of Wisconsin, Law School, Yang Ding, Renmin, University of China, Julia Kaiser, Albert Ludwig University, Freiburg, Wanting Chao, Shanghai University of International Business and Economics, Huan Wu, Shanghai Jiao Tong University, Elias Tuamisto, University of Turku, Linus Katzenbach, Bucerius Law School, Alex Lucio, Cornell Law School, Olivia Stolzenwald, Humboldt University, Berlin. Now you can clap. Now, the second runner-up is Anna-Lena Rothbard of Bucerius Law School. Anna, are you here? Yes. The first runner-up is Timothy Kelland. There. And the winner for the prize for the best oral advocate goes to Thomas Purnell.
Thank you.
You can keep those.
What?
You can keep those.
I hope everybody's had your main course by now. Anybody not had a main course yet? Everybody's eating, good. All right, so we'll be back in a few minutes. I have your attention again, please? Can I have your attention, please? The next award is a kind of special one for us at the Vis East Moot. This one is very special because the nominations for this award come from you, from the students, from the teams. It is the Spirit of the Moot Award, and I'd like to ask Pavan Swami to come up and present that award.
Distinguished guests, my dear friends, it gives me great pleasure to announce this year's Spirit of the Vis Moot Award. This year's Spirit of the Vis East Moot Award was nominated 7 times by 7 different teams. The nominating teams came from all around the world: Australia, Russia, Spain, Germany, India, and China. There were also 2 teams that nominated themselves. You know who you are. But this team, if you came across them, you'll definitely know who they are. I'd like to read out some of the comments from the nominators. Amazing effort and dedication. Amazing teamwork and networking, and network they did. First time a country from their country came to Hong Kong. Limited funding. Very dedicated and hard-working mooties. Very nice guy and girls. Best spirit. And finally, the best comment, which has obviously come from some very, very diligent law students. They deserve it ipso facto. Some of you may have already guessed which team it is. The winner of this year's Spirit of the Vis East Moot is Mogadishu University from Somalia. I invite you to come on stage. We have Coach Ibrahim and the 2 ladies, Sabrine and Samira.
Can I have your attention, please? This is the moment you've been waiting for, so please sit down and focus your attention up here on the stage. The tribunal has been deliberating, apparently over lunch as well. The tribunal has been deliberating, they have made their decision, and I now leave it to the tribunal to tell you about that.
Ladies and gentlemen, all of you who have been here this morning will agree with us. It was an outstanding hearing, an outstanding performance by both teams, and it was really hard to take the decision, but we had to take a decision, and it was, for those who weren't here, it was Humboldt University. Now, it was the teams were Humboldt University to Berlin against HNLU Raipur. So, as I said, it was a hard decision, it was a very close decision, and in the end, it was a split decision. And may I please ask the team from HNLU Raipur on the stage, please. And then the team from Humboldt University to Berlin, also on the stage. Humboldt. And ladies and gentlemen, the prevailing team of this 23rd Swiss East Moot competition is Humboldt Universität zu Berlin. But please also give a warm applause to the runner-up, the team from HLNU Raipur.
Ladies and gentlemen, if I could just have your attention for just one quick moment first. This all starts with a dream. And congratulations again to everyone who came, who attended. Congratulations to the winning teams. But all of this comes down to the hard work of 2 or 3 people, your Viz East organizing committee. But in particular, today we want to take the opportunity to extend one more gesture of thanks to the 2 top figures of the Viz East, Louise Barrington and Sherlyn Tong. This year, the most out of any, we faced difficulties. These 2 led you through the storm. So please, give it up.
Stay there. I ordered champagne a minute ago, and it came very quickly. Thank you very much. It is a pleasure. And it's a pleasure because of you, but also because of Sherlyn. Real boss.
So what did I warn every single one of you? When you piss off Mary Sal, you piss off all of us, right? Because you all know who the real boss is. See? So, please, let's give a huge standing applause for Ms. Marisol Somerville, who this would never happen without. And also those of you who have made her life hell this week, please do find her and give her an apology later. But again, we always, of course, expect this. We hope that you guys would thank us. But all of this would not happen without all of you. So please give yourselves a huge round of applause. And come back. Come back to Moot, come back to be an arbitrator, but come back because we are one growing family. And Marisol really hopes that we can outgrow the Hopewell Hotel and find another venue so we can fit 2,000 of you.
Well, we're not yet finished. Sherlyn has also done a great job, and she deserves also something. So you receive, emails from her, and you also don't want to piss her off.
Thank you guys very much. This is wonderful.
Oh, it's the V's.
We've got our own Vis necklaces. One of a kind, guys. You don't get this unless you're part of us, so feel jealous. But thank you all. Thank you for a wonderful 23rd Vis East Moot. Hopefully next year, it's okay. Hopefully next year we won't have as many disruptions. Cross your fingers. Vote if you can.
Yeah.
You're good? And with that, you wrap up the 23rd. Yeah. Oh, just kidding. We've got. Oh, yeah, go ahead.
So this is almost the end, but again, Sherlyn and Marisol, it takes a village, but mostly it takes them. So there's one more person we should hear from, and that is the representative of the group which will help you to stay in touch with the Moot long after you leave today. and that is the Moot Alumni Association. So Fernanda, you're coming up to give us a goodbye wish.
Well, that's hard to speak after all of that, but good afternoon, everyone. If we haven't gotten a chance to meet yet, I'm Fernanda. I'm one of the vice presidents for the MAA. If we haven't met, that also probably means you weren't in the Moot Bar enough, so maybe do better next time. So exactly a week ago, you were all in a room just like this one, hearing people talk about being a part of the VIS community, being a part of the VIS family, what this experience meant for all of them, and how much it changed their lives. And maybe a week ago, you sat there thinking, that sounds like a bit much. Is that really that important and that big? And I know because once, when I was there, sitting in your place, I would hear people say all of that and say that they had been coming back to the Moot for more than 10 years. And I would think, maybe these people need to find a hobby. That sounds like a really long time to be invested in something. But then, as I participated, and now that it's been almost 10 years that I'm doing this year after year, I can truly say that it is true that the VIS Moot has changed the trajectory of my life. So what I hope for you is that after all that you've experienced this week, and not only this week, but for the past 6 months that you've been working on this, you sit there and you think, that isn't much. I do feel like I'm a part of a community that I want to come back. And that maybe 10 years from now, you'll be trying to explain to your friends and your family that yes, it does make sense that you're traveling to Hong Kong again, and that no, you don't want to use your vacation time to go do something else. I hope that this week you have met people that you will bring into your life forever. I hope that you actually take the trips to visit the people that you've met and that you've said several times over the past few days that you'll meet again. And I hope that, as they have just said, you keep coming back to the VIS Moot family and the VIS Moot community. It's very important that for everyone, and I think that as students, you now see how much your coaches have given back to you, how much the arbitrators that come back every year have given to you, and I hope that you can be a part of that. I'll encourage, of course, all of you to join us at the MAA. We do open our core team applications if you want to be even more involved. But don't join just because we're telling you to. Join because you truly feel that you want to be a part of this community forever. So we welcome all of you to the VIS family, and we hope that you stay.
And with that, I declare the 23rd Willem C. VIS East International Commercial Arbitration Moot officially closed. See you next year.
And just one final housekeeping, because I know how great all of my teams today are at reading the rules, reading our emails, and the team account. For those of you who had won an award, they will be available, the hard copies, on that table over there. For the certificates of participation, they will be available in your team account electronically. For the score letters, and this is in the rules, they will also be available in your team account within the next 2 weeks, very likely not before Vienna, so please do not email us for your scores. If you don't receive something by the end of March, then you can email us. Enjoy, go to the Moot Bar tonight if you're still in town. Please remember your forever friends and family. Thank you.